We are 4 months in since the Employment Relations Amendment Act became official. But the question on everyone's mind still remains. Have these laws actually been tested? This episode is part of a 3-part series tackling the legislation, what cases we have seen so far, and the questions you all sent through a couple of months ago. In part 1, we are doing a deep dive into the $200K dismissal threshold and the 90-day trial period changes you may have actually missed with all the other changes that were coming out. So let's get into it. Hi everyone, welcome back to Law Lenz. I'm Sanam and this is the Employment Law Done Right podcast, where I help businesses get their people decisions right. I'm here to give you that legal thinking without the legal bill. First things first, how cold has it been? It has been freezing, and I'm talking about wind combined with rain combined with just a gloomy day. I hope everyone that is battling the cold is staying warm. I know it's been a while since I've been here, so I'm getting back into the swing of things, but it has been a bit of an adjustment, so thank you for being patient with me. A couple of months ago, I came to you all and said, hey, what are your questions about the Employment Relations Amendment Act? It's all come in. Do you have anything that you want to know? And a lot of you guys sent through questions, so thank you so much for emailing me and DMing me. I really appreciate it. It has been great to put all of this together and to do this 3-part series, but I thought it would be a way to break everything up so you're not employment law. So as much as I love it, it can be very dry and boring. Let's be honest. Now, this piece of legislation, it is the longest winded name, so I'm going to just call it the Amendment Act. And as we know, it came into force on the 21st of February this year. And it's been the most significant shift in New Zealand employment law since about 2018. And there are 4 main changes that have come up. This episode is actually about the first change that we were kind of hearing about when everything was coming out, and it's to do with the high income threshold. So you've probably heard about it, very similar to Australia. Now New Zealand has a law that basically stops employees from being able to raise a personal grievance if they earn $200,000 or more per annum. There was also another change, a very tiny change, but an impactful change that came into the 90-day trial period claims. I thought, why not tackle them both, a big one and a little one, in this episode? We're 4 months in now. There's still a lot of confusion. I'm hearing from people, I don't know what we can actually do. Should I be doing this now? Am I doing the right thing? Is my contract still compliant? So today, don't worry, we're going to tackle all of it, and we're going to tackle all of the listener questions and the LinkedIn questions that I got as well. Like I said, this came in on the 21st of February. It was revolutionary. We didn't think that we would see it probably, but we knew it was being fast-tracked and going through, but it all kind of just came in one go. And it came around my wedding time, so I was not front and center looking at all of the employment laws, but you best believe I did hear about it and did see it on LinkedIn when I jumped on every now and then. Under the new legislation, there are 2 particular sections that have been changed. And one of them, if anybody cares, is Section 67I, and the other one is Section 113A. Basically, what those sections say is that an employee that's earning over $200,000 or more in annual remuneration, they can't bring a personal grievance for unjustified dismissal. And an employer does not need to follow a process as per good faith obligations. So annual remuneration is not base salary. I know this was thrown around quite a bit when the law was being introduced or the bill was being introduced, but we have a formula. We have the law in place now, and it is calculated using a specific formula from the piece of legislation. So the Act has something in there that basically says looking at all the PAYE income paid in the 364 days prior to the dismissal decision day. That means that the base salary, bonuses, commissions, and benefits like employee share plans and share schemes are all included. The only thing that is excluded from what I have seen is ACC earnings related payments. But for the most part, when you're looking at your employee and what they're doing in the workplace, we are talking about everything on the table. And the formula analyzes actual payments made, so adjusted for the time in the role, how much has been paid to that employee. And you can see where this can get a bit tricky, because if you're looking at the base salary, a person that's on 170,000 base, you'd be going, we're all good. Less than 200K. But let's say if we throw in a $20,000 bonus in there, a $15,000 share scheme benefit, then all of a sudden you've got somebody sitting at 205K and now the threshold is being met. So you really have to look at that entire package put together. Let's talk about what changes when that threshold is met. What don't you get as an employee, and what benefits does an employer get? Well, effectively what happens is that an employer does not need to follow a process as per good faith obligations under Section 4, meaning they don't really need to consult with the employee. They don't need to give reasons for the dismissal. They just need to comply with the notice period in the employment agreements. And this is such a departure, such an incredible departure from the 25 years of employment law that we have seen. So this is very, very shocking, and I can understand why, but we know we are very pro-employer here at Law Lenz, and I do think that this comes with a lot of benefits. And I'll get into what I have seen, because as some of you may know, I practice in both Australia and New Zealand. I have seen this play out in Australia time and time again, and I can tell you that yes, there are some employers that may use it as a way out. For the most part, all of the employers that I've seen personally in Australia have used this to actually try to get the team back on track and try to get a person in senior leadership back on track. Those are the things that are changing if the threshold is met. So if you meet that 200K threshold, and we'll get into what else you need, but if you meet that, then those are the things that are disappearing. And that's what an employer can do. They can comply with the notice period in the agreement and have a look at terminating the employee. Now, what stays the same? The threshold only removes the right to bring a personal grievance for unjustified dismissal and unjustified disadvantage that relates directly to the dismissal. These employees can still raise a personal grievance for discrimination, for harassment, sexual harassment, and contractual obligations still apply. And that is where employers, I think, will get caught out, is these two areas, because a bad exit can still become a breach of contract claim. And funnily enough, while I'm talking about this, I saw the 2025 Employment Relations Authority annual report that they put out. So they usually put it out for the year before. And what they did was they looked at 2025, and specifically out of 3,070 applications and matters that went forward, 537 of them were breach of employment agreement related. So that is very much alive and well in terms of being a problem without all these employment law changes. Another aspect that will stay the same as well is good faith in other parts of the employment relationship. So obviously not being misleading, making sure that you are being constructive with the employee, that you're providing them with all the information up front, consulting with them, maybe not necessarily about the dismissal, but in all aspects of the employment. And remember that unjustified disadvantage claim is only relating to the dismissal. So if there is any other kind of disadvantage that's happened, that's all up for grabs if the employee raises a personal grievance. What's happening right now is that we're going through a bit of a transition period. We are adjusting. And for employees on existing employment agreements, which are before the 21st of February, 2026, there is a 12-month transition period. Effectively, what that means is until the 21st of February, 2027, so you've got 7 months up your sleeve. During that window, existing employees above the threshold can still raise unjustified dismissal claims. The threshold doesn't automatically apply to them yet. Employers, HR, everyone out there, listen to me when I say that this is the time your higher earners can try to get these things over the line. Now, the reason why I mention this is because now is the time they can negotiate. But if you are doing it, I would highly, highly recommend that you go and speak to a lawyer, because they will be able to guide you and direct you in the best way possible, and also make sure that the clauses are compliant with your business. So you may be thinking, what's the downside? And I think I've hinted to a few of them along the way, but a lot of employers are reading this threshold as a free pass for a senior team member. And I completely get why. But there's data from Australia, and all we have to do is look across the ditch. Australia has a very similar threshold under their Fair Work legislation, and they've had so for years. This is not anything new to the country. And what happened when it was introduced is that senior employees that were being exited out of a business and dismissed, they still brought their claims, but they just came in a different way. We're talking about breach of contract, discrimination, maybe harassment. And what we really need to think about here is that when you're dealing with senior employees, it's a lot different. When you have somebody that leads a team of 50, 30, whatever it may be, that person is responsible for a lot of people's morale, for a lot of leadership of those people, and also they are responsible for a lot of the people decisions that companies make. You know what I'm talking about? When you're in a larger corporate or in a larger business that requires managers to own the entire process, then they learn a bit of employment law along the way. So they end up knowing their rights and they understand how to use them. Duncan Cotterill put something out last month and they said it really well. They said switching off the unjustified dismissal route does not switch off risk. It just redirects it. That's the trap. And you have to be very careful around that trap because employees can still raise a personal grievance for grounds such as discrimination. Prohibited grounds are broad. And because they're broad, they capture a lot of different things. So the reason why I'm honing in on this is because the Human Rights Act and the legislation that spells out the discrimination, it talks about physical disability or impairment, physical illness, but then it goes into psychiatric illness, intellectual or psychological disability or impairment. So what can happen based off of that is that you could have somebody, maybe a C-suite employee, somebody at the exec level, $215,000 per annum. You give them notice, no reasons, all perfectly legal under the threshold, but the person's 58. They had a health condition that you knew about. And now their lawyer is not arguing unjustified dismissal, they're arguing against age and disability discrimination. So do you see how we can get into a situation where it's a bit of a double whammy, or you could get into a situation where now they're looking at other avenues? So what's my personal take on this? Look, I don't want to fearmonger. I don't like doing that at all. What I want you to realistically think about is what the threshold actually gives you, because it gives you confidence. It gives you confidence to have honest conversations with senior leaders when things aren't working out. And that is genuinely the useful part. Use it intentionally. Start looking at it from a more commercial perspective. But have your guard up. Be careful of the other sides of personal grievances. And to be honest, those personal grievances can come up regardless of the situation. And it could be that employees may flock to doing it, and then we realize very quickly there are vexatious claims with no backing behind them. Be careful of those kinds of personal grievances. And the best way I would say to do it is be clear on the real reason for your decision. Write it down. There's no harm in having just a rough idea of why you are doing this in terms of what the business decision is. Tie it to the role and the individual's performance. Make sure it's not anything that looks like a prohibited ground. Check your reasoning as well for assumptions. It can't be about age, it can't be about health, gender, ethnicity, and then the threshold gives you a cleaner exit. So that's why I'm saying it does not give you a free one, but it does provide you with a little bit of flexibility. Navigating the stuff is exactly why I run bespoke workshops. Getting your managers and your senior exits handled properly before it becomes a claim is critical, right? It's business critical. I don't know if you know about this, but the Law Lenz website just went live and workshops are fully bookable. If your teams need training, whether it's performance, disciplinary, medical incapacity, how to handle mental health conversations, anything under the sun, I provide bespoke training to get your teams on track so they don't have to keep running off to HR, so that they can handle people decisions quickly, efficiently, and without added risk. Go ahead, check it out. It's lawlenz.co.nz. Okay, so what can you do right now? Well, firstly, pull a list of every employee that is near the $200,000 mark. Include their bonuses, their commissions, their share scheme benefits, not just their base salary. And if anyone is close to that threshold, get proper advice on whether they sit above or below it before you take any action. Why? Because there is a very distinct formula in the employment relations legislation that you need to follow. And it's best if you get some advice around that. And I always say this to HR teams. What's the harm in getting a bit of advice? If the company can afford it, why not go and get some advice? When you go and get that advice, you can use that and reapply it wherever you want. If you have an existing employee that's above the threshold, you have a window, use it. And remember, right now, they can negotiate their contractual protections. As we move ahead with this as well, if the legislation still stays in place, then you will get more senior employees that will be negotiating different kinds of protection. You can see if they will choose to opt into maybe a different kind of clause. Now, you may be sitting there going, Sanam, what human being is going to agree to getting all of their rights taken away? Well, my friends, let me tell you about a place like Canada. The reason why I bring it up is because I do advise outside of Australia and New Zealand. I have quite a bit of experience now in a lot of jurisdictions, and Canada is one of them. Canada very much have a termination without cause clause, which basically say that an employer will pay X amount of money or X amount of weeks of pay if they want to terminate you without without cause. Generally, that will provide the employee with a bit of leeway and a bit of a ramp to get moving into their next role, and that will also provide the employer a way out. It could be that they want extended notice, they might want specific severance terms, or they might want parachute clauses. So both parties can also agree in writing for the threshold not to apply at all. That is explicitly permitted under the legislation. And currently in your new agreements, make sure that you have the correct clauses. If you want to present that offer and say no PG pathways, then make sure you have the correct clause. And you would want to roughly mention some of this in the clause, that the parties agree that the employee's annual remuneration meets or exceeds that remuneration threshold set out in the Act, that the parties explicitly confirm that the high income default applies to this agreement, and also that the employee is not entitled to raise a PG or bring any legal proceedings for unjustified dismissal, disadvantage, where that disadvantage relates to the dismissal, and the employer may terminate the employee under this section with this amount of notice, so that we bring in the notice period again, and then the exclusion takes effect only where the employee's remuneration meets or exceeds that threshold. If at any time the employee falls below, then the employee's full rights in respect of a PG are in force, and the employee then confirms that they have had reasonable opportunity to seek advice and they understand and accept what the terms are. Generally, what happens is that when you're drafting clauses, you'll think that I'm simplifying it, it makes sense. But then when you have a third party reviewing it, every word matters and each word has a meaning. Each piece of punctuation has a meaning, and it can really get down to that level of scrutiny when you're starting to look at a breach of contract. So it is important to make sure that your clauses are ironclad. But like I said, go out, get some advice, use that advice later on, and you can reapply it, but it's a good place to start for now. Now, the last thing I wanted to update you on was the quick 90-day trial period update. The Act actually tightened the 90-day trial period to close a well-used back door that was always being used, if I can be honest. Previously, an employee dismissed under a trial period could bring an unjustified disadvantage claim that essentially challenged the dismissal by another route. So even though you might have a perfect, very, very valid chef's kiss 90-day trial period clause and everything that you've done is all valid, boxes all ticked, done all right, they could still come in from the disadvantage angle. And boy, oh boy, was it frustrating. There were so many times where, you'd make sure that everything was done right. You'd make sure that you kept the employee in the loop. You did everything. And then when you see that disadvantage claim come in, you think, why? But the good thing now is that if you have a perfectly implemented trial period, if you've ticked all the boxes and done all of the right things, then you are well protected because now the route is actually blocked. If the trial period is valid, the employee cannot raise an unjustified disadvantage claim if it relates to the circumstances of their dismissal. So obviously, like with everything else, if it's something related prior, then that is a separate issue. But if we're talking about the dismissal itself, then now the employee has no pathway to raise that claim. So what you can do right now is just review your 90-day trial period process, not just your templates, but the actual process that you've got. The agreement, remember, needs to be signed before any work is commenced. The employee needs to have enough time to review the contract. And there is a whole raft of things that you need to do to ensure that your trial period is valid, not just having a clause in your contract. And employers are still getting trial periods wrong. I have an episode on the 90-day trial period process, and you can always check that out. And I will link that down below as well. All right, let's now tackle the questions that came in. The first one, which was good, I really like this one because it's straight to the point and it's true. Can we use the threshold for redundancy and skip the consultation process? Very clever. But this was one of the most common questions I've been asked. And it's the same question that comes up quite a lot with the 90-day trial period. And the answer is proceed carefully. The threshold absolutely removes the requirement for a good faith dismissal process, but redundancy is still a dismissal. And for employees above the threshold, yes, technically you could skip full consultation, but massive caveat here. What does your employment agreement actually say? Because contractually, you might still have employee protection provisions. You might still have clauses in there that say that we will consult with you and we will discuss this with you before moving ahead with any kind of redundancy or restructure or workplace change. And the good faith obligations in the broader relationship still apply. So if you bulldoze a long-serving executive through a redundancy with no warning, expect a breach of contract claim or maybe even a discrimination argument to come up. So the threshold is not a license to behave badly. I know some employers may have done this, but like I said, for the most part, I haven't seen any employers do the dodgy with their senior employees. So another question that came up was our exec wants to opt back into the personal grievance rights. We're not so keen. Do we have to agree? No. You're not legally required to agree. The Act allows for both parties to agree in writing for the threshold not to apply, but it's a mutual agreement, so you can say no. What this creates is a negotiation. Like I said to you before, you might get into these negotiations, particularly for new hires or promotions above the threshold, and you're going to get strong candidates. So expect for a push. You're going to have people that will understand what they want, they know about these laws coming in, and they will want to basically negotiate with you as a condition of signing that agreement. So the conversation is worth having with your employment lawyer before it becomes a sticking point during that recruitment process. So definitely reach out to a lawyer if you need to. Now, somebody said that they have somebody that is quite senior who has been with the business for 8 years and they are on $210,000 total. Can we just act on the threshold now? The answer is no, because the person is on an existing agreement, they are on that 12-month transition period. And that means that until the 21st of February, 2027, they retain full unjustified dismissal rights. And the last question that I got is that our general manager is on $190,000 base, but they get a $15,000 company car allowance and an annual bonus. Does that push them over the threshold? Yes, it most likely does. If total remuneration, including salary, the car allowance, the bonus, and the share benefits reaches above $200K or more, the threshold applies. And the formula uses actual payments made over the past 364 days, not just what's in the employment agreement. If they've received $205,000 in total payments in the last year, they are above threshold. Pull the numbers and don't do any guesswork. Now, I'll wrap this one up, everyone, because you must be tired of listening to me and we've got a couple more episodes to go in this series. 3 things from me today. One is that the $200K threshold is a total remuneration, not a base salary, and you need to run the calculations properly. It is not like when I do girl maths, it will have to be done correctly. Please speak to your employment lawyer so that you can get really tailored, structured advice, and like I said, that you can reapply. 2 is existing employees are protected until February 2027. And 3, discrimination, harassment, and contract claims all remain. So make sure that you understand that the threshold just narrows one avenue. It doesn't remove all risk, and not everything is free game. If your team is making these calls and you want them trained properly, this is what I do. I live, eat, and breathe this stuff. And like I said, the website for Law Lenz has officially launched, and the workshops that I am running are now open. I make them bespoke and tailor them to your teams and make it something that's fun, long-lasting, and impactful so that you can get on with it and actually implement it straight away in the business. So head over to lawlenz.co.nz and have a look around and maybe book a workshop for your team. That is it from me, everyone. Thank you so much for your time. Don't worry, this is not over yet. There is still more left. I will see you in the next part of the series. For the meantime, I hope you have a lovely day, night, morning, evening, whatever it may be, and I'll literally catch you in the next one, everyone.